I just want to do God's will, and He allows me to go up to the mountain.
You probably learned about the Civil Rights Act in school, somewhere between the Underground Railroad and Martin Luther King Jr. It was written so formerly enslaved Black people could sign contracts, buy things, sell things, participate in the economy. This isn't going to be about that. In 2024, the Civil Rights Act was used to shut down a grant for Black women entrepreneurs. There's a serious and dangerous argument circulating through the corridors of the judicial branch, and it goes something like, the way to end discrimination on the basis of race is to stop acknowledging race entirely. In other words, any program designed to help Black people just because they're Black is itself a form of discrimination. The principles of this argument prompted the Supreme Court to strike down affirmative action and is now being applied with methodical precision to everything else. College scholarships, law firm fellowships, a $20,000 grant was the first casualty. Betina Benson came to entrepreneurship the way a lot of Black women come to it, alone at night, teaching herself things other people get taught. She built a clothing brand named for her daughter, and for 7 years, she did everything herself. Design, patterns, cutting, sewing, shipping, inventory, accounting, customer service, the whole organism of a business held together by a person who didn't have the option of hiring help because hiring help cost money she didn't have because nobody would give it to her. In 2023, she applied for a grant from something called the Fearless Fund. $20,000 awarded to Black women building businesses. Not a loan, not an investment that would take a piece of her company, just money given to her. Because someone had looked at what she built and said, this is worth something, and so are you. In a country that has made Black women prove themselves twice over for half the consideration, that kind of recognition is vanishingly rare. It is the thing that almost never comes. And when it does, it changes the shape of what feels possible. 1 year later, a federal court ruled that it couldn't happen anymore. The Fearless Fund was started in 2019 by 2 Black women, Ariane Simone and Ayanna Parsons. It was built on a set of numbers that most people in venture capital prefer not to discuss in polite company. In 2024, Black founders received 0.4% of all venture capital invested in the United States. In other words, for every $1,000 flowing into U.S. startups, $4 went to Black founders. Black women received a fraction of that fraction. In 2016, fewer than 12 Black women had ever raised $1 million in venture capital funding. Ever. By 2023, that number climbed to around 164, which is progress of a sort, but only the sort that could fit comfortably in a mid-sized conference room and still leave seats empty. These numbers are not the result of Black women failing to have ideas or lacking ambition or building inferior companies. These numbers are the result of a funding ecosystem that has decided through 1,000 small calculations and assumptions and gut feelings that somehow Black women are too risky an investment. This driver's grant was a workaround. $20,000, no strings attached, for Black women who were building businesses in an economy that would not build with them. 4 years, thousands of women funded, and then Edward Blum sued, and the window became the subject of federal litigation.
And now it's facing a lawsuit by the American Alliance for Equal Rights. That's a group founded by the conservative activists. Now, this suit alleges that the fund's Fearless Drivers Grant Contest is, quote, their words, a racially discriminatory program that blatantly violates the Civil Rights Act's guarantee of race neutrality.
Edward Blum is not a white supremacist. If he were, this would be easier to explain and file away in the category of problems that solve themselves when the generation holding them dies off. Blum is something more durable, a true conservative believer in a certain idea of equality, in which the remedy for past discrimination is to stop discriminating now, completely, without remainder. In his view, any program that takes race into account, even to repair or address specific damage done to specific people for specific reasons, is itself a form of racism. And for over 30 years, this logic has proven to be devastatingly effective at dismantling the legal infrastructure built to help Black people participate in institutions that excluded them for centuries. Blum doesn't hold office or give speeches at rallies. He builds cases. He finds plaintiffs, constructs arguments, files suits, and waits. It took years losing before he won his first case. Fisher v. University of Texas went to the Supreme Court twice, and twice it didn't give him what he wanted. Then the court changed. Students for Fair Admissions versus Harvard made it to the highest court in June 2023. 6 justices, 3 of them appointed by Donald Trump, ruled that race-conscious admissions policies violated the Equal Protection Clause. 50 years of precedent reversed. Affirmative action in higher education functionally dead. Bloom's case, Bloom's plaintiffs, Bloom's win. Harvard was never the point. Harvard was the vehicle. As the vehicle, it moves into new contexts, attaches to new facts, and the people who established it get to decide where it goes next. After Harvard, Bloom's organization, the American Alliance for Equal Rights, filed 9 lawsuits in 18 months targeting law firm fellowship programs, corporate diversity initiatives, and venture capital funds that invested in minority founders. The Fearless Fund's Strivers Grant was one of 9 targets. The same principle that killed affirmative action at Harvard can kill a $20,000 grant for a woman selling clothes she designed at her kitchen table. Section 1981 of the Civil Rights Act of 1866 was written in the first stunned breath after the Civil War, when the country was trying to figure out what it meant that 4 million people who had been property were now citizens. The problem was immediate and practical. Freed Black Americans were shut out of economic life. They couldn't sign contracts, lease land, buy goods, or even participate in the basic transactions that make a life livable. White business owners refused to deal with them, and there was no law that said they had to. Section 1981 said that all persons shall have the same right to make and enforce contracts as white citizens. Bloom's argument is consistent and has a certain geometric elegance. The Fearless Fund's grant is a contract available only to Black women. White women are denied the same right to said contract. Therefore, the grant violates Section 1981. The law that was written because Black people were being denied the right to participate in economic life is now the law that says you cannot create programs to help Black people participate in economic life. On June 3, 2024, the United States Court of Appeals for the 11th Circuit, a 3-judge panel split 2-1. The 2 in the majority, Kevin Newsom and Robert Luck, were both appointed by Donald Trump. They found that the Strivers Grant likely violated Section 1981, that a program designed to help Black women was, in the eyes of the law, no different from a program designed to exclude them. Injunction granted, the program stopped immediately. The dissent came from Judge Robin Rosenbaum, appointed by Barack Obama, and it is worth reading in full if you want to understand how the law becomes a game played on a field where the rules keep changing. Rosenbaum pointed out that the plaintiffs, anonymous women, represented by Bloom's organization, had never actually applied for the grant. There was no violation because they had never demonstrated any intention to start a business or shown any injury beyond the abstract, theoretical kind that exists only in legal briefs. The majority did not respond to this because standing doctrine has become a formality in cases like this. You don't need an actual injury to sue. You just need to articulate an injury in the right language. Whether anyone was actually harmed is beside the point. Fearless Fund announced a settlement on September 11, 2024. The Strivers Grant ended permanently. While a win, Bloom wanted a case that would go all the way to the Supreme Court and a ruling that would establish, as a matter of national precedent, that any private program taking race into account violates federal civil rights laws, not just university admissions, not just government contracts, private philanthropy, your foundation, your scholarship fund, your decision made with your own money about who you want to help. If Fearless had fought the case to the end and lost at the Supreme Court, the blast radius would have been enormous. The NAACP scholarship programs, law firm diversity fellowships, corporate funds for minority entrepreneurs, hospital programs to address health disparities, programs meant to repair the harms of slavery and Jim Crow by directing resources to Black people would have been vulnerable. One ruling and the legal foundation for race-conscious philanthropy collapses. Fearless saw where this was headed and killed their own program permanently so that the case would end in the 11th Circuit instead of traveling to Washington. The ruling stays in Alabama, Georgia, and Florida. It does not become the law of the land. Not yet. Fearless Fund fell on a grenade to save everyone standing behind them. But here's the thing about grenades. There are more of them. Strategic sacrifice or not, falling on one only works once. Bloom's organization has 9 lawsuits currently pending. Other groups inspired by his methods and emboldened by his success have filed more. And one of them could become the vehicle that reaches the Supreme Court. The only thing protecting the rest of these programs right now is the absence of a final judgment. There is no constitutional guarantee or shield or principle, just the lack of legal precedents. the law that was written so Black people could participate in economic life